in just a moment.
It's 9:30 and here they come. Look at
Oh,
that.
there they are. Magic.
Ask and you shall receive. It's the dream team. Thanks, guys, for showing up today.
Thanks for having us.
Good to have
Welcome.
you back, Adam.
Always happy to be here.
I actually got to meet Adam for the first time in person this year, so it was great meeting you. We had been done some stuff virtually, but it's nice to see everybody back again.
He's very tall.
I realized that. What, 6'5"?
6'7", but who's counting?
6'7". Oh, okay. That is tall.
Hard to tell on the Zoom box. I wouldn't have known. All right, well, now we know Adam's height, but I'm going to tell you a little bit more about our speakers who we have joining us. As I know, a lot of our attendees on the call are lawyers, so I'm sure a lot of you are familiar, but for those who aren't, I'm going to take a moment to introduce Adam and Aaron before they get into their case law update. So Adam is a partner at Epstein Cole LLP and has worked there in some form or another since 2013. Adam was called to the bar in 2013 after completing his clerkship for the Senior Family Justice, the Associate Chief Justice, and the judges at the Ontario Superior Court of Justice. Adam has authored and co-authored numerous papers. He has presented for the Halton County Law Association, ILCO, the OBA, and the LSO, and some other places with acronyms. Adam is an adjunct professor at York University. Adam co-authored Unpacking Family Law for Practitioners with Justice Melanie Kraft. Thank you so much for being back here, Adam. Looking forward to hearing from you again. And next we have Aaron Franks, who was called to the bar in 1998. Since his call to the bar, he has practiced exclusively in the areas of family law and in the defense of solicitors' negligence claims. He's an adjunct professor at the University of Toronto Law School and was previously an adjunct professor at Osgoode Hall Law School. He was formerly an instructor with the family law section of the bar admission course, and he is a dispute resolution officer for the Superior Court of Justice in Toronto. He has co-authored This Week in Family Law since January 2020. He is presently the editor-in-chief of the Reports of Family Law and was associate editor since 2005. Aaron is a regular contributor and speaker at continuing legal education programs, and he's authored papers and chapters in several publications on family law issues. He is also listed in Lexpert and Best Lawyers directories ranked in Chambers and Partners Global High Net Worth Guide and Family Matrimonial, and is a fellow of the International Academy of Family Lawyers and American College of Trial Lawyers. He is a member of the Planning Committee for the biannual National Family Law Program run by the Federation of Canada Law Societies and was previously co-chair of the 6-Minute Family Lawyer for 8 years and on the board of Advocates Society. So thank you so much, both of you, for being here.
Everybody knows who Aaron is.
I figured, but
there's nothing worse than listening to somebody read your resume. I can't stand it. But if you have your mother write your resume, you too can have a resume.
If you don't know who Aaron is by now, you must just be starting off in family law. But great resume.
Well, on that note, Aaron and Adam, I will let you take it away.
Okie dokie. Well, again, thanks very much for having us. We appreciate it. We are going to go through some of the, not necessarily the most important cases of the last year, but certainly some of the most interesting cases. We will sort of go back and forth as we go through them. If there's any that are of particular interest, we can get the list of sites to Shannon and Russell to pass them out. So the first one I want to deal with is a case from Justice Kraft in Toronto called Gerasimopoulos and Sambursky, which is actually, despite what I said before, quite an important case. It deals with parenting and mental health. Mental illness historically is very, very misunderstood. There is a fair amount of stigma attached to mental health, and it's very hard for sort of people to understand that, you know, when somebody suffers with mental illness, when they are unwell, but when they are well, they are completely and totally fine. It's very different from someone that suffers with a broken arm. Broken arm, you can see, you can understand it, but there is a stigma attached with mental health. And we hear words like depression or OCD or borderline personality disorder. There's a very significant stigma attached to these words. And Justice Kraft in her decision goes a fair distance, if not all the way, in trying to destigmatize people with mental health issues. So briefly, what happened in Gerasimopoulos It was a fight over a parenting schedule with respect to kids that were aged 9 and 6. Father did have a history of suffering with mental illness, but he had successfully managed his condition with medication and seeing his psychiatrist. He had a good job. He earned a 6-figure income. Things sort of unraveled in 2019 and into 2020. First, the father lost his job, and then COVID hit. And it's shocking how many people decompressed during COVID, but he was one of the COVID victims. At the same time, his marriage started to unravel, and that forced on a manic episode in sort of the middle of 2020. He was arrested by the police. He was admitted to St. Joe's for 9 days. During that time, the mother took the children from the home, and that was the official end of the marriage. Father was released from the hospital. Mother, in the meantime, brought an ex parte motion for sole decision making and a temporary restraining order, and for temporary primary residence, which she was successful on a very short basis. At a case conference subsequently, the father agreed that he would stay 250 meters away from where the mother was living, but also agreed that the father would have some limited parenting time, 3 days a week, supervised by the mother's brother for a total of 8 hours per week. So a fairly restrictive parenting regime. Over the course of the next several months, the father's life significantly stabilized. He followed his treatment plan. He found new employment. He remained under the care of his psychiatrist, Dr. Duff, and followed Dr. Duff's treatment recommendations. He moved out of the matrimonial home to live with his mother in Niagara Falls, and to show his commitment to the kids, he actually commuted from Niagara Falls to Toronto 3 days each week in order to have his supervised parenting time. Despite the improvements in his mental health, and in fact that his manic episode was long past him, all of his requests for additional parenting time were completely refused by the mother. In fact, he was only finally allowed to have his first unsupervised visit about 16 months after his original 2020 episode. In 2022, the parties attended parenting mediation. They agreed into a phased-in sort of shared parenting schedule. Father first started with 5 out of 14 nights and then increased to 6 out of 14 nights. And then in the final phase was going to be returned to mediation to figure out whether or not it could actually be a full-on equal schedule. Father continued to see Dr. Duff, was doing well, agreed he would continue taking his medication, agreed to refrain from smoking, drinking, and to keep away from all of his triggers. All of it went reasonably well until, unfortunately, the father experienced another manic episode in June of 2023, and even more unfortunately, it was witnessed by the children. The father's father became concerned because he canceled a visit that was supposed to happen. The father's father called the police to do a wellness check. Father wouldn't let the police in the door in the midst of his manic episode. The police had to break down the door in front of the children. The father had prepared a last will and testament while he was holed up in his home and had his 8-year-old witness his signature. It was just bad. Just generally a bad scene. The children later reported that they were scared. They just wanted to be able to feel safe with their father. This, of course, made the entire parenting plan that was reached in mediation completely unravel. Eventually, father regained his mental health. This time, the mother was not at all cooperative and actually took several steps to try to thwart the father's ability to try to set up another parenting schedule with the kids. Justice Kraft granted the father unsupervised parenting time, starting with 4 to 14 nights, increasing to 5 out of 14 nights at the start of the 24-25 school year. She also granted him sole decision-making over the children's sports and extracurricular activities. But the most important part is what Justice Kraft had to say about parents that suffer with mental health. And it's a roadmap for counsel with clients with mental health issues as to exactly how they should set themselves up to present to a judge to show that they actually can handle their children. They can be effective parents, even though they have mental health issues. Keep in mind, this may not work for children that are very young, infants, but once kids are old enough to sort of handle and to notice signs themselves, as I say, this regime will work. Justice Kraft noticed that first of all, the mother had been asking for supervised access, so Justice Kraft goes on to supervise the conditions necessary for supervised access and notes that it's really just a Band-Aid. Supervised access isn't meant to be a long-term solution. She did find that continued supervision was not necessary, especially because of the regime that the father had agreed to enter into, and the fact that he was actually taking accountability for his mental health, and the fact that he did suffer with this mental illness and wasn't sweeping it under the rug. He also agreed to what Justice Kraft called a 6-part safety plan that was developed by Dr. Duff, his psychiatrist, including that the father was to contact the mother upon him sort of experiencing the aura or the feelings he would usually have before a manic episode. He gave permission for his treating psychiatrist to have open conversations with the mother. He gave the mother the freedom to contact the psychiatrist if there were any problems. Father agreed to maintain his medication. Father agreed to full release of his clinical records. And the children were also taught the signs of what to look for so that they could be on the lookout for things as well. Justice Kraft rejected the mother's concern that the safety plan required the father to self-report, and because of some of the mother's conduct, she actually came to the conclusion that the mother was not actually trying to help the father regain his parenting status, but was actually working against it. What Justice Kraft says, she basically repeats what Dr. Duff has to say, and that bipolar 1, which is what the father had, is a manageable condition, and if properly managed, people with bipolar can be very high functioning. That said, people are afraid of it. It's a difficult disorder to understand, that someone can be unwell when they are unwell, but perfectly well when they are healthy. Dr. Duff specifically testified that the stigma of bipolar is that people still don't trust the person with bipolar or misjudge the person or blame things on them. So Justice Kraft really does a good job of sort of looking at this historically and undoing or a fair amount of the stigma that's attached with not only bipolar disorder, but with any sort of mental health illness. And while she notes that while no one can guarantee that the father won't have future manic episodes, the father is showing that he's prepared to bend over backwards to do everything in his power to present an episode. So it's a very important judgment to read. Mental health is sort of, I don't want to call it a cause celeb these days, but there's been a lot of attention paid to it. Justice Myers has written about it. Our former Chief Justice has spoken about it. And now Justice Kraft has written a very sensitive and nuanced decision about it. So it's an important decision for all to read, not only because of what it has to say about supervised access, but this is the first real judgment in a long time that deals with these issues sort of head on. So I commend it to you. Mr. Prewer.
So just off the top, there was a question. There's a paper that will be circulated that has all of the sites and the summaries that we're talking about today. So you don't have to worry about sort of rushing to write them down. So the case I'm going to be speaking about is JFR and KLL. It's a case from the Ontario Court of Appeal. And this deals with actually a very interesting and our important question about how do you approach a parenting order for an adult child, which is always sort of a troubling term, but in this case, an adult child with a disability. The appeal involved M, who was a 26-year-old man living with Down syndrome. He could not live independently and had always lived with his parents. He was financially dependent on them. Initially, the parties separated in 2012, and M was a minor at that point. He has a younger sibling as well, who was also a minor, and the parties agreed to an equal timeshare arrangement. Everything was fine, and then COVID-19 hit. During the pandemic, the parties agreed that M would temporarily live with his mother to minimize the risk of exposure to the virus. Then in October 2020, the father sought to return to the shared parenting schedule that had previously been in place. The mother refused, and the father commenced an application. He brought a motion for an interim order returning the parties to the shared schedule. And it's very important, but M was not named as a party to the proceeding or formally served with notice of the proceeding or the motion. And he had no opportunity to make submissions. At the time of that motion, he was 24. The motion judge first determined that she had jurisdiction to make the temporary parenting order because M met the definition of a child of the marriage under the Divorce Act. Specifically, child of the marriage is someone who is under 21B, over the age of majority, and under the charge of their parents, but unable by reason of illness, disability, or other cause to withdraw from their charge or to obtain the necessaries of life. So here, the judge determined that M was still a child of the marriage because he couldn't leave his parents' charge due to disability. That followed that the court then had jurisdiction to make an interim order. What's interesting is the judge first made an order that there had been no evidence, aside from the mother's own assertions, that the shared parenting schedule was detrimental to M, either in a physical, emotional, or psychological sense, and ordered that the parties restore the full parenting schedule. Then the judge takes another intriguing step, which is that they ordered that the parties retain a social worker or psychologist to interview M, attempt to elicit his views and preferences within 6 months, and after that period, the order would, quote, become final. First issue that the Court of Appeal deals with, which is very interesting, is that this is to the Court of Appeal. And the reason why it's to the Court of Appeal is because the motions judge made a determination of jurisdiction. If it's an issue of jurisdiction, that goes to the Court of Appeal rather than where the normal path for a motion is, which is to the Div Court. The mother argued that M should have been named a party and had the opportunity to provide submissions at the motion. M was independently represented by counsel at the appeal, which the Court of Appeal had ordered. And as we will see, that was very important to the Court of Appeal. While the motion judge was alive to the issue of M's views and preferences, the Court of Appeal determined that having a psychologist interview them was no substitute for M's participation, and M was presumed to be a capable adult in the proceedings. The fact that he was not able to participate wouldn't be remedied by simply ascertaining his views and preferences prior to making a final order. And this case gets into the right to be heard, which is in Latin, the audi alterum partum, which is a fun Latin maxim, so rarely do we get to break those out. And it is in fact a rule of natural justice. And if you are in a court proceeding or a court proceeding is being made about you, you have a right to be heard and to have counsel. And the Court of Appeal really emphasizes the right to be heard is particularly important in cases like this that involve persons living with a disability. And as a result of that disability, they may be dependent on others. That doesn't mean they don't have a right to ensure that their interests are protected and their views are made known to the court. Dependence on others or incapacity in some areas doesn't mean that there is incapacity in all areas, and it certainly doesn't eliminate the right to be heard. Court of Appeal goes through a number of great summaries as to how the right to retain independent counsel works, how it protects the presumption of capacity and the right to make one's own decisions. It sets out that the presumption of capacity is only rebuttable under precise conditions with clear evidence. And those stringent requirements are necessary to protect the autonomy of people whose capacity is at issue. Court of Appeal set out that there are varying levels of capacity. So a person might be capable of making a basic decision, but not a complex one, or maybe they can make decisions about personal matters, but not financial matters. Capacity is, in the words of the Court of Appeal, a spectrum, and it is not an all or nothing proposition. In many cases, the rights, the capacity, and the voice of adults with disabilities can be lost, and the Court of Appeal is very concerned about that. The Court of Appeal talks about that not only is capacity a context-specific analysis, but the phrase withdrawal from parental charge in section 21B, or say 21B of the Divorce Act, is also context-specific. So an adult child may be able to withdraw from parental charge for one purpose, but not another purpose. And the court's focus should be on whether they're able to withdraw from parental charge in relation to the particular order sought. In this case, M couldn't withdraw from his parents' charge. He was dependent on them financially, but that didn't mean he didn't have a voice as to where he wanted to live, where he wanted to spend his time, and who would be his caregiver during that period. What is very interesting is the Court of Appeal set out that an adult who is presumed to be capable, including in cases where you're dealing with an order sought under the Divorce Act, and is potentially affected by the order in question, should be served with the notice of proceeding and afforded the opportunity to obtain separate legal representation and to participate fully, including in the adjudication of any capacity issue. So that is certainly very important for these sorts of cases. And the Court of Appeal doesn't deal directly with it, but you can sort of analogize here. If you're making a claim for child support for an adult child, all of those conditions would seem to apply. They're certainly adults, they're presumed to be capable, and they will be potentially affected by the order. So it may be good practice to actually serve adult children when we are dealing with child support related claims, which are not infrequent in our courts, dealing with post-secondary expenses in particular. Oftentimes there are also situations where people are making orders that may infringe on the autonomy of a child. And again, it's when those children are adults, adult children, a difficult term, they need to have the opportunity to participate. The next case I'm going to talk about.
Adam, just before you go on to your next case,
Yeah, absolutely.
just in our continuing efforts to bring you the latest and uppest to datest, in Saskatchewan, a very similar case, and it looks like the Ontario case and Saskatchewan case were sort of proceeding in parallel, but the Saskatchewan Court of Appeal, just like literally at the end of August, released a very similar decision in a case called Albers, Aalbers. It's actually not in our paper, but a very similar sort of idea that an adult child with a disability may still have capacity in order to make decisions. So sorry for the interruption. On with
Watch
it.
the newsletter. I'm sure it'll be there.
Exactly.
The next one is a case called KMN and SZM. It's from the British Columbia Court of Appeal. Very important case for Ontario and indeed any province. This deals with what a court must and must not do when faced with allegations of family violence that are relevant to the best interests of a child. So there is a lot of really good writing here about how to deal with this. And while the Court of Appeal talks about this under the British Columbia Family Law Act, which is a little strange because it was a divorce, so it should have been under the Divorce Act, the language in the Ontario legislation, the Divorce Act, and the British Columbia legislation is strikingly similar. So this is definitely on all fours in terms of the things we have to consider as well. So when a court is faced with allegations of family violence, a court must meaningfully engage with those allegations. It has to analyze the evidence, needs to make finding of facts, and consider how this will affect the best interest of the child. The court must not limit its analysis to alleged violence against the child. A court must consider alleged violence against a parent and how that impacts the other parent's ability to care for the child. And this is really important. A court must not engage in myth-based reasoning about family violence. And the big myth that goes through the trial judge's decision in this case is that a myth that mothers will regularly allege violence against fathers to gain a tactical advantage in a family law case. This case involved very serious allegations of family violence. They spanned 3 years, so the entirety of the 3-year-old child's life when they separated. It included things as the father headbutting the mother, may have struck the child at one point as well. At one point at a exchange, the father grabbed this mother's cell phone and broke it. And at one point, after the father had headbutted the mother for the second time, she ended the relationship and she moved. The father then started a claim and got an order that she had to return back to the jurisdiction she was in. She had moved within BC, but 3 or 4 hours away. There was an interim order for parenting where the judge acknowledged that there were significant concerns about the father's violence and ordered that he had 1 overnight every weekend. And then this was expanded to 2 overnights per week. And that's really where the father's time stayed at, that 2 overnight a week level. At one point, it dipped down again after there was an exchange and the father assaulted the mother during an exchange and was subsequently charged. His time was then restricted and then sort of expanded again. There was a parenting assessment completed by Dr. Elterman. Interestingly, the assessment doesn't seem to actually make any recommendations for what the schedule should be, but instead recommended that both parties engage in counseling and other therapeutic programming, and to obtain an updated report to consider what further changes should be made so the child can, quote, again, have 2 parents in her life, end quote. No update was obtained before the trial. It was an 8-day trial. The mother, who was self-represented at the time of trial, sought a continuation of the supervised parenting schedule, and the father was looking for an equal share. The trial judge ultimately sided with the father and ordered a 12-week step-up schedule resulting in the father having the child from Friday afternoon and 6 out of 14 nights, and none of the father's time was supervised. And the trial judge stated essentially that there was no valid reason that the father should not have longer periods of parenting time, eventually equal parenting time, and having, quote, considered all of the evidence, equal parenting time is in the best interest of the child. No danger to the child has been found in the evidence called by the mother in the dealings with the essentially the equivalent of Children's Aid Society, or in the opinion expressed by Dr. Elterman. This was appealed, and the mother argued that the trial judge failed to actually analyze the children's best interest in accordance with the analytical framework mandated under BC's Family Law Act, which is similar to the Divorce Act and similar to the Children's Law Reform Act. Courts have to consider allegations of family violence, have to consider family violence. In this case, the real issue that the trial judge fell into is that he didn't make any findings about the allegations of family violence. But he did seem to indicate that he actually said, I agree with the father that the mother had made these allegations for tactical or strategic purposes. However, to make that finding, the trial judge needed to actually analyze the mother's testimony, analyze the alleged acts of physical violence and threats towards her, and he had to determine that they were false and that they were done for strategic purposes. The BC Court of Appeal sets out very clearly that this is the trial judge falling into the myth that people make up these allegations in order to gain a strategic advantage. It is a very concerning, very insidious myth that is thrown around a lot. It is particularly difficult for clients to rebut these sorts of things because family violence happens behind closed doors. This was set out by the Supreme Court of Canada in Barendrecht, which is a 2022 case. Domestic violence allegations are very difficult to prove, and they often lack corroborating evidence because it's just the two people in the room, the aggressor and the victim. The failure to prove on a balance of probabilities that an act of domestic violence did not occur does not mean it didn't happen, and certainly doesn't mean that it was falsely alleged. And the BC Court of Appeal is very, very clear about that. In fact, the disposition of this was that the entire thing was sent back for a new trial, with the Court of Appeal cautioning the new trier of fact to carefully assess the merits of the family violence allegations and not fall prey to myths and stereotypes. And in the meantime, the Court of Appeal ordered that the father's parenting time be supervised, which demonstrates the concern that they had about the evidence that the mother had brought forward. This is a very challenging issue, a very important case to read, whether you are dealing with a client that is claiming that the other side is, quote, making it up, or whether you are indeed dealing with a case where your client has experienced family violence, some of the most difficult cases that we will deal with. There was another case in 2023, Friesen and Friesen from Saskatchewan, which sets out some great principles as well to guide us. And at the end of the day, these are the things we need to think about. These are the things we need to be sensitive to. We do acknowledge that weaponizing these claims can happen. We're not saying it never happens. However, it is much less pervasive and much less widespread as people would sort of try and make one believe. And as Aaron and Michael said, what's a trial judge to do? Listen to the evidence, consider the evidence, apply the burden of proof, and make factual findings on these important allegations.
My next two cases are both about alienation, and they're from late 2023. And the reason we've included them and the reason they're important is because one being from Justice Kraft, one being from Justice Finlayson, they both offer examples of how these cases are to be handled. We have all seen trial judgments that talk about the fact that this case has been going on for 7 years and has been in court 57 times and takes up 32 banker's boxes, and there were 45 interim orders. Those cases are the death knell for an alienated parent in a true alienation situation. In both YHP, which is Justice Kraft's case, and GRG, which is Justice Finlayson's case, both of them deal with alienation the way it should be, which is swiftly and then with continued case management from the court. Allowing these cases to fester, allowing them to go on forever, allowing one party to simply string the thing out and drag the puck simply is enigmal to the whole idea of trying to fix the situation to the extent it can be fixed. And the really interesting thing about both these cases are that there were custody reversals, and in one case, use of the Family Bridges program on an interim motion. So these weren't final judgments. These were two cases where two judges, two very experienced family judges, recognized the signs, recognized the problems, and said, enough, we are going to deal with this right now. And in fact, in GRG, a sidebar, I can't stand the fact that all these cases are initialized now because I can't remember them. But in GRG, Justice Finlayson actually takes the Children's Aid Society to task for not actually involving themselves and allowing the parties to duke this out themselves privately in court, when he said at least in the case before him, it was clearly a situation where there were children in need of protection, and actually ordered the CAS to become involved and ordered somebody from the CAS to show up at the next return date in order to explain what exactly they were doing. So it's not the facts that are as important as the actual process, but very high level. In YHP, Justice Kraft was met with a situation, again, where one parent behaving badly. Parties were married for about a 6-year marriage, had one child, daughter. Daughter was 12 years old by the time that this motion showed up before Justice Kraft. Parties separated in 2014, whereupon the mother alleged the father had sexually abused the daughter. The allegations were investigated by the police, found nothing. Children's Aid Society found nothing. The SCAN team at Sick Kids found nothing. Office of the Children's Lawyer found nothing. Other various medical professionals, including the child's doctor, all of whom found nothing. But the mother persisted in her allegations and refused to allow the father to have unsupervised parenting time. At some point, the OCL did a report in 2016, said the child was actually quite comfortable with the father. In 2017, the mother seemingly saw the light and allowed the father to have time with the daughter again. Unfortunately, the light went out fairly quickly, and upon COVID happening and other sort of case that's the victim of COVID, mother retreated to her old ways and made it virtually impossible for the child to see the father, claiming the child didn't want to see the father, reinvigorated her allegations of inappropriate sexual contact vis-a-vis the daughter, reported to all the agencies again, actually interfered with counseling and barged into one of the counseling sessions between the therapist and the daughter to suggest that the father was dangerous. Father brought an interim motion to actually bury what was then a final order, to ask that custody be switched and to ask that the daughter be engaged in the Family Bridges program along with him. Justice Kraft goes through a very detailed consideration of all the case law about, first of all, making interim changes to a final order, which is a whole area of law into itself, but she goes through it really quite well. And then talks about the fact that given the mother's egregious behavior, she really had only 4 choices. She could do nothing and just leave the child with the mother. She could reverse custody and place the child with the father. She could leave the child with the mother and order therapy, or she could provide some sort of transitional placement with a third party. She said, well, in fact, only A and B were left as options because the other therapy hadn't worked and no one had really asked for, and there wasn't really a third party that could take interim custody. So the options were to do nothing or to reverse custody and place the child with the father under some conditions. And Justice Kraft said doing nothing is simply not an answer, as should be the answer in many of these cases. So Justice Kraft ordered again, this is an interim motion, ordered a custody reversal, child to live with father. Child's, I think it was 12 years old at this point, as I said. Ordered a 120-day blackout period, meaning that the mother could have no contact with the daughter for that 120 days. But Justice Kraft also cleverly put in place, and also ordered the participation in the Family Bridges program. Also, however, set up an immediate case management judge to manage the case so that the case could be regularly reported on back to the court to determine whether or not the 120-day blackout period was just right, too long, not long enough, and to determine how the Family Bridges counseling was actually working. It's a very well-written decision about this area, and again, exactly how I suggest courts should deal with these issues to avoid them being those, 15 banker's box, 45 attendance cases. Secondly is Justice Finlayson's decision in GRG and SG, a very similar flavor to it, Justice Finlayson's decision, however, is an interim variation of an interim order, which is a separate text unto itself. But very similar situation. One parent behaving badly, allegations of inappropriate sexual conduct that had not been verified. By this time, there had already been 20 orders or endorsements. 5 other judges had been involved, and Justice Finlayson said, enough. And he actually also, on an interim basis, did something about it, and again ordered that the Children's Aid Society show up and explain why they hadn't done anything, which I'm sure did make the Children's Aid Society all too happy. But I mean, it's pretty clear in a case of whether or not one calls it parental alienation syndrome or just parental alienation or unjustified estrangement, something had to be done, and Justice Finlayson, just like Justice Straff, went ahead and did it. If you are dealing with a case, or if you're representing a client who is in that sort of situation, I will say that these 2 cases are must-reads because they deal with both situations, interim variations of final orders and interim variations of interim orders. But these are, it's too early to tell whether or not these 2 cases are just sort of blips, and these 2 cases happen to land up before very experienced family law judges who had been very experienced family law lawyers, or whether or not this is actually going to be an ongoing trend, because for all sorts of reasons, including, being careful with our sort of scarce court resources, this is exactly the way these cases should be dealt with. Very quickly, as it's amazing how quickly time flies, there were 2 grandparent access cases that we will include in the paper. One is again an initial case, FS and NG and TS. Good luck remembering that. That's a case by Justice Scher. And the reason that's a good case for grandparent access is, in typical Justice Scher fashion, he sets out the playbook. He says, here is the way that you deal with these cases. Here are the 2 sort of streams that the cases have sort of developed, or the 2 roads the cases take. One being sort of the parental autonomy model. Think Chapman from the Ontario Court of Appeal. Unless a parent is behaving badly or acting capriciously, a parent gets to decide who their children spend time with, as opposed to the other model, which is the sort of pro-contact model, which is that contact should be assumed unless there's a contact with a grandparent should be assumed unless there's a reason not to. But he sets out sort of the whole guidebook, as I say. It's a good synthesis of all the current principles, and of course, Justice Scher numbers all his principles. Just makes life very easy for lawyers. And then in the second case, Kirschenblatt, Justice Himmel in Newmarket takes Justice Scher's decision in again, I have to go back to the name of it, I can't remember the initials, in FS and NJ, and actually applies it to the case before her, which was a case arguably of both parents and grandparents behaving badly. And in this case before Justice Himmel, things are a little bit different, because while one child did have a history of some contact with the grandparent, the other child didn't. So Justice Himmel had to grapple with the idea of, what do we do here? Unfortunately, Justice Himmel was given a bit of an easier task, because the parents had agreed that the grandparents could continue time with the older child who they had time with, not the amount of time the grandparents wanted, but some hours a month. She said based on that, it would be incongruous to say one child can have contact but the other cannot. But nonetheless, she still goes through the test and considers what is to be done in situations where there's a history of perhaps one parent never having had contact, or also considers the situation, even though it was over during this decision, as to what happens in a situation whereby one of the parents dies, and it's the dead parents that are actually the ones that are looking for access as grandparents to the kids. So 2 very good recent grandparent access cases that, if you're dealing with grandparent access, are both must-reads.
So I'm going to move away from parenting now. Next 2 cases.
Because Adam hates children.
Infamously. This is what everyone knows about me now. I hate kids and I'm very tall. Great. Perfect. So Anthony and Anthony from Nova Scotia and Frost from Ontario. These are the 2 cases you go to when you get a massive disclosure request from the other side and you do not want to provide all of it. Anthony is from Nova Scotia, but a fantastic case. It sets out all of the things that you need to be considering, whether you're responding to a disclosure motion or bringing one. It sets out really some of the most important things that people forget, which is you need to establish relevance, and you need to do more than just rely on your pleadings. So you need to actually provide evidence as to why something is relevant. And the threshold for establishing relevance is low, but it is there. And the need for evidence is essential. I am looking at you, my friends, who have sent in disclosure motions where you have just attached a letter from your expert. Thank you. That doesn't explain the relevance of the requests. That's not enough. There are a number of really great factors that Justice Fogeran sets out in Anthony, what are called the Loshway factors in Nova Scotia. And it sets out whether something should be provided. There are 10 of them. You consider connection, proximity, discoverability, reliability, proportionality, important, alternative measures, privacy concerns, balancing, objectivity, and limits. So those are the 10 factors, 10 considerations that a court needs to consider when it's ordering disclosure. And even though they come from Nova Scotia, they're equally applicable here in Ontario or anywhere else. Frost and Frost focuses on the concept of proportionality in disclosure, and it is a really great case by Justice Jane. Well written, well reasoned on an important point. Too often, I think we can sort of get lost in disclosure fights. In this case, the husband prepared a 15-page chart that listed the many hundreds of disclosure requests he had made over time, and all of the ones he claimed were outstanding. However, he had not provided any evidence as to why these disclosure requests were relevant, why he needed them, and why it was proportionate for the wife to provide them. The wife, on the other hand, provided very clear evidence showing that she'd actually really tried to comply with those disclosure requests, and had answered undertakings and provided a lot of relevant disclosure, thereby leaving her in good stead with the court. There is a great summary of a decision by Justice Mesber called Crescent, which sets out factors when you're considering proportionality, specifically that the parties in the court need to consider the time required to produce the information, the expense associated with the production, whether there is any prejudice that would be caused through production, i.e. whether there's confidential information there, and whether production would interfere with the orderly progress of litigation, and whether the requested document is in fact available. Does it exist? Slightly different than the Loshway factors, but still important. Here, husband had not even come close to establishing that the extensive disclosure he was seeking was relevant and proportionate. Didn't even bother making a shot at it. Justice Jane provides a really important sentence in paragraph 8, where she states no procedural decisions should be made without specifically addressing the principle of proportionality and without first considering whether the request is a deviation from the requirements of Rule 13 and the family law rules. Very important case when it comes to disclosure. If you are making a disclosure motion, you need to be in line with Anthony and Frost. If you are resisting a disclosure motion, you should be citing these cases in your factum as well.
Sase 2?
Sase 2, trying to speed it.
I'm going to spend a little bit talking about foreign divorce and a couple interesting things that have happened in that area over the last couple months. I have actually spoken about this case before, Viazemskaya and Safin. Ironically, even though there's a name for it, Viazemskaya and Safin, I know it as VNS, back to the initials that I actually don't like. This is a case about recognition of foreign divorce. The setup is essentially that parties lived in Russia, parties had a child in Russia, parties were Russian citizens, parties came to Canada. Not long after they came to Canada, they decided, you know, this whole marriage thing, we don't like it. They separated. Father went to Russia, got a divorce in Russia, based on the fact that he was a citizen. Mother participated in the divorce in Russia to the extent that she contested she contested the issuance of it. As I say, it was still issued. Parties came back to Canada, case returned to Canada. Mother claimed the usual panoply of family law relief in Canada, to which father said, hang on a second, mom can't claim spousal support because we're divorced. So I will remind you all about the Rothgeser problem. Because of the division of powers in our Constitution, the federal government in the Divorce Act only has power to legislate about spousal support if the parties are subject to a party to a Canadian divorce. So that's why the Divorce Act can't be used if you're not married, because if you're not married, you can't get divorced. And if you can't get divorced, the federal government has no jurisdiction to order corollary relief in the form of spousal support. And for the same reason, if you're divorced in a foreign jurisdiction like Russia, because you're not party to a Canadian divorce, according to the case of Rothgieser in Ontario and some other cases in Ontario and elsewhere, you can't claim spousal support under the Divorce Act. That leads to a further problem, because once you are no longer spouses because you're divorced, you are former spouses, and under our act in Ontario, former spouses can't claim spousal support, which leaves a spouse that is subject to a recognized foreign divorce screwed, is the word, completely screwed, because they can't claim spousal support anywhere. And if you're in a jurisdiction like Russia or Texas, where spousal support isn't so generous, you got some problems. So wife tried to set aside the divorce. Well, not try to set aside, try to suggest that Ontario shouldn't recognize it under Section 22 of the Divorce Act. First, she claimed she didn't have notice of it. Therefore, that's one of the foundational principles. If you don't have notice of it, Ontario will not recognize it. The difficulty was, having contested the divorce, it was hard for the wife to suggest she didn't have notice of it. So that wasn't going to work. Other problem for the wife was that in that decision, in that very first decision, the court had noted that the parties did have a real and substantial connection to Russia, which is a really important phrase, because that means that Russia has jurisdiction simpliciter in order to deal with something like a divorce. But that attempt by the wife to have the divorce not recognized failed. So she tried again, based on the idea that the Russian divorce, strike one. Now she went for, pitch number two. She tried to suggest that the Russian divorce should not be recognized because of public policy, which is, according to the Supreme Court of Canada in Beals and Saldana, a basis to not recognize a foreign order. However, when you look at Beals and Saldana talks about repugnancy of foreign laws, not repugnancy of conduct. So say what you will about the husband. Say the husband was a schnook. Say the husband did this on purpose. Say the husband set out to specifically try to not have to pay spousal support. It's not the behavior that matters. It's the law in Russia. There's nothing wrong with the divorce law in Russia. Russia allows parties that are citizens to get divorced. Divorces there may happen more quickly than in Canada. But as the Court of Appeal ultimately says, you can't impute the entire Russian legal system because of the way they decide to deal with divorces. So, however, the court below on the second attempt does say, yes, you know what, there is something wrong with this. We are not going to recognize the foreign divorce. Off they go to the Court of Appeal. The Court of Appeal sort of recognizes the problem here with Beals and Saldana, but seizes onto this one line from Beals and Saldana that talks about unfair forum shopping. So they say this is actually another basis to not recognize a foreign order. We have public policy, we have fraud going to jurisdiction, and we have unfair forum shopping. Well, here the husband engaged in unfair forum shopping, therefore we should not recognize the foreign divorce. The problem with that, and I realize pretty much every member of the Court of Appeal is far smarter than I am, but in my simple mind, I don't understand how you can be found to have engaged in unfair forum shopping, asking for relief in a jurisdiction where you are found to have a real and substantial connection. That is a bit of a problem to me. However, they do develop this new basis to not recognize a foreign divorce, or any foreign order for that matter, because we're not only talking about divorces, of unfair forum shopping. The other problem with that is that it suggests that you can have fair forum shopping, which is something I never understood that you could do. Forum shopping is generally something that courts don't look favorably upon. So there's now forum shopping and unfair forum shopping. And of course, the problem here is that, bad facts and intransigent governments make bad law. In many provinces, BC, Alberta, eastern provinces, Manitoba, they have specifically legislated that former spouses can claim spousal support, which makes a great deal of sense. Why Ontario has been so stubborn, not entirely sure. However, something has been done about it. Last week, over the course of 2 days, in a case called Marillion and Dunmore, there is a constitutional challenge suggesting that Section 33 of the Family Law Act that limits the right to claim support to spouses, not former spouses, is unconstitutional, unfairly differentiating between foreign spouses subject to a divorce and Canadian spouses subject to a divorce. I did not argue it. I know about the arguments, and anecdotally, the court seemed very receptive to the idea that there was a problem here. That doesn't mean a thing. It just means the argument went in well. Don't know ultimately what's going to happen. I do know that whatever side wins, this is ultimately going to land up at the Ontario Court of Appeal. So this issue is being dealt with. Interestingly enough, this was litigation that proceeded pursuant to notice of constitutional challenge. And for reasons that I really can't understand, the government intervened on the side of the father here, technically, saying, yeah, the law shouldn't be changed. Former spouses should not be allowed to claim spouse support, which is something I just don't understand. You would think the government would be all over the idea of foreign spouses subject to a divorce not having to be on the social welfare rolls because they can claim support from their former spouse. So I just don't understand it. Maybe somebody was concentrating on selling alcohol in corner stores rather than on, the unfairness that, happens sometimes in these situations. But we will have an answer to this, although it may take some time because, as I say, it's going to go to the Ontario Court of Appeal. As long as we're talking about Morelia and Dunmore, a separate chunk of that case is also now going to the Supreme Court of Canada, for those of you that want to keep tabs on these things. And the issue that the Supreme Court of Canada is going to be dealing with is the parenting part of Morelia and Dunmore. And the question they're going to answer is whether or not, you'll all remember F&N that dealt with the return of a child in a non-Hague situation. The Supreme Court is now going to deal with whether or not provincial statutes, like the Children's Law Reform Act, all of which are based on a model code, that most of which, if not all of which, actually have their own baked-in definition of habitual residence, whether or not bailiff and office of children's lawyer and the definition of habitual residence from the Supreme Court of Canada in that case actually infect and change the definition of habitual residence in the provincial statutes. And I use the word infect advisedly because I am not a fan of what the Supreme Court of Canada did to habitual residence and the notion of it in bailiff. But again, just my personal opinion. And finally, we all know, with respect to the Supreme Court of Canada, Aliwilia has been granted leave. People are in the process of filing their stuff and interveners are getting involved. I think it's going to be argued in December, I want to say. I could be wrong, but certainly very soon. So we'll have sort of an answer to that. But that is sort of the uppest to datest on recognition of foreign divorces.
So I'm not going to go into detail on my next case, Pan and Zhao. It's a decision by Justice Vela. It is I think the most up-to-date family law case dealing with anti-suit injunctions. It sets out a number of useful pieces of information, a very good analysis on when a court can take jurisdiction over a matter, when a person can be found to have adorned to a jurisdiction, the test for forum non-conveniens, that's in there as well. And Justice Vela does all of that work before she then gets to an analysis of how anti-suit injunctions work and a specific application in family law. Essentially, in this case, the husband had adorned to Ontario's jurisdiction about everything, but he had started an action in China and wanted his action in China to continue because he was claiming a tort in China against the mother for mental damages caused by her infidelity. That does not work very well for him. There's an important process point here. One of the reasons it doesn't work well for him is that the husband provides no evidence as to the law in China concerning as to whether or not he could actually make this claim. It's something that a lot of people ignore, but is important. Foreign law, you have to prove it as a piece of evidence. You can't just say, this is the law of X country. In addition, Justice Vela stated that not being able to pursue a claim for compensation based on alleged adultery wasn't something that was going to justify holding up the wife's claim. That's not a claim we have here in Ontario for good reason. And the anti-suit injunction that the wife sought was indeed successful. So an important case for anti-suit injunctions, very important. I guess the other case that I have, Eldridge and Eldridge from the British Columbia Court of Appeal, a fantastic case when it comes to the issue of reviews. It's got a lot of language about what does a de novo review mean and what is the effect of a de novo review. A great case for that. It also is very, very well written in terms of dealing with whether something that you think is going to happen in the future is a reason to review support. In this case, a husband essentially wanted to reduce support because he thought he would probably sell his business in the near future. I'm being a bit facetious there. He was in his mid-60s. It was pretty reasonably on the horizon, but the court set out that you actually can't do that because it is not a certain event. It is one thing that may happen in the future. There's a bit of discussion in our summary about exceptions to that. Cases in both Alberta and Ontario where courts have seen an impending retirement as a material change and a reason to alter support. However, in those cases, it was very clear as to when it was going to happen and what the effect would be. Also, I love this case because it involves two archaeologists that get married. So anything that reminds me of Indiana Jones is just great for me.
I'm going to talk very quickly about White and White. And very quickly about Nom-Chom and Green. White and White is interesting because it's a case from the Ontario Court of Appeal. Interesting for two reasons. A number of years ago, the Ontario Court of Appeal decided a case called Levy and Levy, L-A-V-I-E, which suggested that a court really, when imputing, if you're imputing income to one spouse, you should really seriously consider whether or not you should be imputing income to another spouse. In White and White, they impute income only to the wife and not at all to the husband. The situation was the parties had separated, signed a separation agreement saying that that the wife, that if the wife earned more than $35,000, for every dollar above $35,000 she earned, her support would be reduced. Wife had sort of mused about going to Mexico and starting a travel business in Mexico. Oh, but we all could go to Mexico and start a travel business in Mexico. And anyways, perhaps unsurprising, she never actually earned more than the threshold. In the meantime, father lost his job, had been earning about $189,000, showed up in court earning about $80,000. The court thought it to be quite legitimate. He hadn't done anything on purpose. He lost his job and got another job earning what he could earn. Father showed up for a variation. Court said, yep, we're going to vary because there had been a couple changes. Number one, father's income had reduced. Number two, the children had sort of moved around a little bit. But most importantly, the court said, yeah, there's really no reason that the wife isn't earning income. Importantly, in the separation agreement, everybody knows that in the Divorce Act, one of the factors and objectives, or one of the objectives of spouse support is to encourage one spouse to do what they can to become self-sufficient. That has time and time again been described as not a duty, but just one of the considerations. Here in the separation agreement, the wife had actually obligated herself, basically just parroting the words of the Divorce Act, to make reasonable efforts to support herself. That, so said the lower court and the Court of Appeal, transposed the, call it wishy-washy duty in the Divorce Act, or the Statement of Principles in the Divorce Act, to actually an obligation. So she actually created the obligation to actually go and earn some income, and having not done so, the court thought it unacceptable and imputed her $35,000, and did not impute income to the husband, even though he had been earning $189,000 and showed up in court earning $80 because they were convinced that he, in fact, had not been engaged in anything nefarious, wasn't artificially under or unemployed. So interesting to read that in comparison with, as I say, Levy and Levy. Lastly, Chom and Green, just an interesting comment from our Court of Appeal on occupation rent. We've all read Fafano and Green, and we've read Griffiths and Zambasco. All of them are fairly old cases, both from the Court of Appeal. So all lawyers in Ontario sort of feel that occupation rent is sort of an irregular thing to have ordered. It can be ordered, but it's an exceptional remedy. Court should be slow to order it, should be ordered cautiously. When it was ordered, it was sort of just used, to even things up a little bit. Things perhaps were tipped, too far in favor of one side. They could use occupation rent to fix it a little bit. In Non-Chom and Green, the court says, while it is settled law in Ontario that an order for occupation rent need be reasonable, it need not be exceptional. So this really has sort of opened the door to occupation rent. All you have to do is basically prove that your claim is reasonable, be that because sometimes there's ouster, but you don't need to have ouster. Sometimes somebody refuses to cooperate in a sale. Sometimes somebody delays in a sale. It could simply be that one party does the good thing in a separation and agrees to move out and then get stuck outside the house for a long time. So occupation rent awards are no longer exceptional. They just have to be reasonable. And when you combine that with a recent case from from actually the Newfoundland Court of Appeal, called Soros and Goss. In Soros and Goss, the Newfoundland Court of Appeal actually said that you'd have to show exceptional circumstances for an award of occupation rent not to be made. So, you know, it is a new day for claims for occupation rent. So go forth and claim.
So we are right at the edge of our time. I will just say this: if you want to have a case that will break your brain, read Falsetto and Falsetto. It is essentially you are allowed to claim a resulting trust, even though you told the government for Planning Act purposes that you were absolutely not an owner. You can then claim in the next thing that you can, despite the fact that in Ontario Court of Appeal case called Holtby and Draper explicitly said you couldn't do that. So Falsetto and Holtby don't sit together very well. And I highly recommend reading Moran and Moran. It's a decision by Justice Kraft. It is a very good description of what it means to hack into someone's computer. There, the person who did it had very little tech, didn't really guess a password, didn't have to do anything fancy, but got access to privileged information. And Justice Kraft walks you through how to deal with it. A very important point, but it doesn't, you know, hacking doesn't mean you need to be breaking in or having some sort of tech skills.
Great job, Adam and Aaron. I'm now up as to datus. I'm going to have occupation rent in all my claims as the item number 1. And beer in the corner stores, liquor in the corner stores, we're moving towards a free and democratic society. So
That's right. Section 7 all the way, baby.
Inspired me. Tell me what's going on with the Superior Court downtown. They get these alienation cases, and do they have a bullhorn? Do they just say Justice Kraft clean up on aisle 5, and they just send it down to her courtroom?
Yeah, I realize, as Adam mentioned this is a little bit turned into the Justice Kraft show, which wasn't meant to be. But you know, she's written some really good, she writes well, and she's written some really good decisions as of late. And as far as alienation cases go, I think what you really need is someone who is a judge that practiced family law for a long time, that sort of smells it, and knows that if we don't do something now, eventually it's going to become too late, and it's going to become one of those cases. So I think that's and Justice Kraft, Justice Finlayson, you know, anybody at the UFC in Newmarket, you know, they all have experience in the vineyards of, you know, matrimonial discord.
Too late to go back, right? If you wait too long. And that's the frustration for a lot of practitioners. The courts are not prepared.
Yeah.
Or traditionally, we're not prepared to do anything until 2 years later. And then
it's too late, right?
Yeah.
Then the kid is 14 or 15. And then you have cases that say, well, we're not going to make an order the kid isn't going to follow. So like, you need to strike while the iron is hot. I mean, obviously it's not going to happen on the first attendance, but it also should, you know, you shouldn't have 13 attendances with nothing happening.
It's refreshing to see the court take a more active role in these cases much earlier on.
Agreed.
Yeah. Well, that was a fantastic presentation. Thank you so much. I took a quick look at your paper. It's excellent. Shannon, any feedback?
No, just want to thank you both again for being here. We really appreciate it, and very insightful. We also appreciate you sharing the citations. Just for anyone who hasn't had a chance to look yet, it is in the chat, but we'll send those out after. So you can keep an eye out there. But yeah, it was great having you back, Adam, and really grateful that Aaron, you're here with us as well. And I know that you know, originally we were waiting for the stars align for it all to work out. So we really appreciate you squeezing it into your schedule.
Our pleasure. Looks like a great lineup. Good conference. Hope it goes well.
Thanks so much.
Talk to you soon. Have a good day, everybody.
Bye.
You too.
That's good.
Bye.
Bye-bye.